Welcome everyone to tonight's CLE offered by the AIDS Legal Referral Panel. Tonight is Chapter 7 Bankruptcy for Low-Income Clients presented by Sally Elkington. And this is our quick agenda. I do want to get into the substantive portion, but I want to tell everyone a bit about AIDS Legal Referral Panel to start. Some housekeeping notes: the training is being recorded. Please remain muted throughout the training unless asking a question or participating in a discussion. We probably won't be unmuting folks. You can use the chat or the Q&A to ask questions. There will be time for questions at the end of the training. You may enter questions in the chat and I'll read them out during the designated question time. But again, this is a two-part series, so you may want to try to remember your questions for tomorrow night. You must complete the evaluation in order to receive MCLE credit. The evaluation link will appear at the conclusion of the webinar and will be shared in tomorrow's follow-up email, as well as linked in the chat at the end of this training. And you'll receive a receipt for your MCLE credit shortly after completion of the evaluation. So AIDS Legal Referral Panel, our mission is helping people living with HIV/AIDS maintain or improve their health by resolving their legal issues. An overview of our work: since 1983, ALRP has handled over 80,000 legal matters for people living with HIV/AIDS, and our staff and panel attorneys help our clients in a variety of civil legal areas, including immigration, housing, employment, credit, insurance, family law, confidentiality, and government benefits. We've handled thousands of legal matters. We have close to 700 volunteer panel attorneys, and 85% of our clients in 2019 had an annual income of less than $30,000. So we rely on our panel to provide low-cost legal counseling and representation on any civil legal matter. Our clients are diverse and appreciative of your generosity. We tailor the experience to your experience and availability. And we ask that as a new panel attorney, you take 2 referrals a year with the option to accept or deny a referral when we contact you. As a panel attorney, you receive free MCLE trainings like tonight, mentoring, malpractice insurance, and other legal resources. So a little bit about the referral process. A client will contact ALRP with a legal issue, and then ALRB conducts a thorough intake with the client. Then ALRP contacts the panel attorney with the opportunity, and the panel attorney determines whether it's a good fit, and then the case is now yours. So you simply report back how many hours you worked on the case and the final disposition. If you need assistance with an ALRP referral, we can provide you with a mentor, MCLE trainings, and other legal resources. To join the panel, visit our website. It's posted here, alrp.org, join the panel online application. You can please contact me with any questions. I'm the Pro Bono Director. My name is Fyra McCandless, and I can be emailed at probono@alrp.org, or you can call me at 415-701-1200, extension 303. So we have a few more CLE trainings for the balance of 2021. On the 28th of this month, we have Zoom mediations and depositions. We have an immigration CLE on October 5th. We have a privacy series that will continue from the previous privacy series that started in the spring. I will be presenting on HIPAA on the 13th of October, and then Jim Wood will be returning to complete the series on November 4th. So our presenter tonight is Sally Elkington. And so I'm going to tell you a little bit about Sally. Sally Elkington is a solo practitioner. Ms. Elkington has been practicing law for 32 years and specifically consumer bankruptcy law for over 25 years. Elkington Law represents debtors in Chapter 7 and 13 and files in all divisions of the Northern District of California, as well as the Eastern District of California. Ms. Elkington served a 3-year term as a commissioner for the California State Bar Judicial Nomination and Evaluation Commission and is a past president of the board of the Alameda County Bar Association and served on the board for 5 years. She has served as both chair and board liaison to the Bankruptcy and Consumer Law section, executive committees, and currently serves on the board. She also served as chair of the Lawyer Referral Governing Committee and currently volunteers at the monthly low-income bankruptcy clinic for Legal Access Alameda. She was selected by the Northern District of Bankruptcy judges to be a member of the Northern District of California Bankruptcy Bench Bar Committee and completed her term. Ms. Elkington received her law degree from New College of Law of California and earned a Bachelor of Science in Speech and Communication Studies in San Francisco State. And she's a longtime dedicated panel attorney. I'm going to.
I got to get on the other side. Technical difficulties, folks, because I don't know how to do this stuff. Okay. Alt tab?
Yes.
Can you see me?
Yes.
Okay. Are we ready?
Yes, we see your slides. We're ready to go.
Okay. Good evening. There aren't many of us, so I expect that if you have questions while we're going through this and it's on the topic that we're covered or just covered, I will take questions as we go, if possible. If I don't get to your question, we'll answer it at the end. You have materials, and the first bit that you have, I want to make sure I sound fine to everybody. So the first couple pages are is the outline that I'm going to cover tonight. And I hope to get through area 5 or property of the bankruptcy estate and exemptions. That's my hope. If I don't, that's where I'll pick up tomorrow, because tomorrow has not as heavy a schedule as today's. So we'll see what we can do. So the first slide, and you have to excuse me some because I'm handling both notes and slides at the same time. So Chapter 7 bankruptcy. Chapter 7 bankruptcy is the bankruptcy you are going to see most people file that are low income. Very few low income people need to file a Chapter 13, and we'll talk about the difference between a 7 and a 13. But let me, if I could have a show of hands of folks, and you, I might not be able to see the show of hands, so maybe I can get that interpreted. But how many people have ever filed a bankruptcy or are familiar with bankruptcy? If you could just show hands on the bottom of the screen there, that would be very helpful. I can't see, so if you can let me know what they say.
I don't see anyone raising their hand, and there's a raise hand feature at the bottom of the screen if everyone sees that, but it's quite possible no one has familiarity.
Well, that's good in some ways, because this is going to be sort of a bare bones basic introduction. to how filing a bankruptcy and how it all works. So Chapter 7 bankruptcy is what we call the fresh start bankruptcy. And Chapter 13, quite frankly, also is fresh start, but Chapter 7 is shorter and much more to the point. So two things happen in a Chapter 7 bankruptcy. One, it gives the debtor at the end a fresh start. They don't have any debts, unsecured debts that they have to pay back. And if they do have non-exempt assets, and we're going to talk about assets, but let's just say assets that we can't protect in the bankruptcy, the trustee's job is to come in and sell those assets, take the amount of money he or she gets from selling the assets, and pay your creditors a pro rata share. So bankruptcy, Chapter 7 bankruptcy, often referred to as straight bankruptcy, is the simplest form. And most low-income debtors, and I would say 99%, are allowed to keep all of their assets because we can protect them by exemptions. Exemptions are in California state law. So we'll go over those, and I've given you copies of the California, the two codes that cover the two areas of exemptions. If a debtor has a non-exempt asset, then the trustee, as I said, will liquidate the asset and pay the creditors. But again, 99% of bankruptcies are non-asset cases. I'm going to go through this part fairly quickly. So, sources of bankruptcy law. First of all, the best source of bankruptcy law, and I have had it here on my desk, but I don't anymore for some reason. Oh, because it's on my floor. I don't know about you, but one of my best filing systems is my floor. So this is the Bankruptcy Code, and it's called the Bankruptcy Code and Rules, and it has the related provisions of the United States Code. It has federal rules of civil procedure and federal rules of evidence. And this is the Bible to bankruptcy. If you're going to file bankruptcies for people, you have to have access to the code, whether it be online or whether you actually get a code. Used to be when I was a bankruptcy attorney back in the day, where we actually appeared in court. We had a judge years ago who, when people came into court, he asked, "Could you show me your codes, please?" And the first time he did this was sort of scary because I didn't carry my code into court. And he was absolutely right. If you're in court, whether it be virtually or in person, you should have your code there as reference. You can reference it as you go along, and you might hear something from another case, and you will hear cases before and after you that you think, "Oh my God, I didn't know that," and look up the code, and there you go, you find it. So it is very important because the code, there's the code, and then there are rules of bankruptcy. Sort of weird, but that's how it works. There's also case law. This is another area of substantive bankruptcy law. And that would be the Supreme Court, the U.S. Court of Appeals, or it could be what we call BAP, which is the Bankruptcy Appellate Panel. And the United States courts and the United States Bankruptcy Court. So BAP, if you appeal something, you could appeal it to BAP. And BAP is a group of Northern District, if it's in the Northern District bankruptcy attorneys that sit on the BAP, bankruptcy judges who sit on the BAP, and they will listen to your case and make a decision. Or you could go straight to the U.S. Court of Appeals. Sometimes it's just easier to go to BAP. Non-substantive bankruptcy law would be Titles 15, 18, and 28. I'm sorry, I am behind. 15, 18, and 28 of the United States Code, and I've given you some ways to take a look at that, and that covers mostly crime and tax-related procedures. Non-bankruptcy law, when the code doesn't give you any direction, it's not in the code, then or there's no rule, then you are controlled by applicable state law. And you'll see that a lot in family law cases, where family law often will be applicable state law as opposed to bankruptcy law. And state law defines what the property, usually what the property, for the most part, state law defines what is property in bankruptcy for the most part. Okay, sources of bankruptcy law, we've already sort of covered. It's important to look at the official, well, let me go back to sources of bankruptcy law for just a second. I do want to mention one thing, and that is, we've talked about the federal rules and the federal rules of bankruptcy procedure, FRBP, are specific rules and procedures that are unique to bankruptcy practice, and it's going to be in the code. Federal rules of civil procedure, because you're in federal court, of course, you are governed by the federal rules of civil procedure. Federal rules of evidence, same thing. And then local bankruptcy rules. That is really important in bankruptcy. You go to the Northern California bankruptcy website and you look at what the local rules are. Local rules tell you how to file certain things that may be in line with the federal rules or may not be, but have been approved as a rule that in your district or division. And then judges all have their own procedures, especially in setting hearings and things like that. So you might want to review that if you have a case that's going to go before a judge. Let me just tell you, most of this is, except for your code, is not, you're not going to be covered. You're not going to have to worry about it in Chapter 7. It's just not going to be an issue. Okay, but one of the things you really need to look at are the official forms, and the official forms often change. So I see that on the slide. I say these can be found at. In your the handout that I gave you. Again, can be found at www.uscourts.gov. So you want to look at bankruptcy forms. Local bankruptcy court forms, and again, this is mostly Chapter 13 and not Chapter 7, but districts often create their own modified versions of official forms, so you want to look at that. And bankruptcy rules or local rules, when there's no bankruptcy rules or local rules, then as I've said, as long as it's not inconsistent with federal law, that or the official forms or the rules of bankruptcy procedure or local rules, then you can pretty much make up your own form. I used to have a judge who isn't with us anymore, who said, you know, it's all about making up your own motions. So that does happen. Okay, let's quickly go over who the participants are. In a Chapter 7 bankruptcy and a Chapter 13, there are trustees. In a Chapter 7 bankruptcy, there are several trustees in each division. The Oakland division is a division. San Francisco is a division. San Jose is a division. Santa Rosa is a division. And I think I've covered them all in the Northern District. And each one of those divisions have their own trustees that have been assigned or basically been made trustees by the United States Trustees Office. Their major duty is to look at the bankruptcy, see if there are any non-exempt assets, and see if they can sell anything. And one of the reasons for this, quite frankly, is Chapter 7 trustees get paid about, I think it's about $80 or $85 per bankruptcy that they look at. And right now, bankruptcies are an all-time low. I mean, really low. And so they're not making much money right now. Bankruptcy trustees in a Chapter 7 are different than the bankruptcy trustee in a Chapter 13 and are paid differently. So every bankruptcy they look at, they get $80 or $85. Every time they can maximize assets and pay creditors, they get a percentage of what they pay out. So you can see their motivation, especially when it's slow, in order to make a living, they're really going to look for non-exempt assets. And they also look at the debtor's petition for fraud and abuse of the bankruptcy system. And they also conduct a 341 hearing. That's the meeting the creditors that you may have heard of. And it happens about 20 to 40 days after the case. And we're going to go into some real specifics of the 341 hearing. They also have the avoiding powers, and that's where they can exercise their powers to recover certain money or property. And we're going to go into that in more specifics as well. They can set aside what we call preferential transfers, and they can undo security interests, and they can undo transfers of property that were not done properly, or the timing was not right or correct. And you can look at 721, section 721, to get a sense of how they can also operate a business. If you file a Chapter 7 to dissolve a business, they can operate the business for a limited time, which would be a benefit to the creditors, and they can close it down. Happens not very often because they don't want to operate that business because of insurance and liability issues. And as we talked about, each trustee earns a commission on the value of liquidated assets. Then you've got your bankruptcy judge. You will very seldom see a bankruptcy judge in a Chapter 7. Very seldom. I would say, again, it happens maybe 5% of the time. The judge plays a more central role in Chapter 13. You also have the debtor's attorney. That would be you and me. And we represent the debtor in the bankruptcy case. We advise them throughout the case. We're going to talk about that in much more detail. And we're going to talk about what you should be delineating in the retainer agreement. And I just want to tell you, and I'll tell you again, we do not have a limited scope retainer. That means you can't pick and choose the things you're going to represent the debtor in. It's all in or all out. Some districts or some divisions will allow you to just prepare the bankruptcy for the client and not make any appearances for him. You're in 100% of the way here, and that's the way it should be, in my opinion. Then there is the creditor attorney. The creditor attorney, in some cases, you'll see one in a Chapter 7, but mostly not. Mostly they're in a Chapter 13. They may make an appearance, in other words, file a notice of appearance to find out what's going on, so they get served with all the papers. But that happens very seldom, again, in a Chapter 7, unless there's assets. And sometimes creditors will hire an attorney just to do that, to look at to look at the bankruptcy and the certainty rights that the creditor may have. If a creditor attorney appears in a non-asset case, it might be because they believe there's a dischargeability issue, and we'll talk about that. or there's an exemption issue, and we'll talk more specifically about that. Generally, creditor's attorney, first of all, bankruptcy is a very civil court. We know each other. The same creditor's attorneys show up for everything. So we have, for the most part, very good relations with them. It's very seldom do we have what I used to see in state court when I did more state court, excuse me, work. So you will know who the creditor attorney is more than likely, or you'll know the firm. It's important. They'll probably call you and talk to you about, or send you a letter and talk to and ask you about certain things, and just contact them back and see what their concerns are. Look back at the bankruptcy, see if there are valid concerns, answers their questions. Most of the time, I'll tell you their concerns aren't valid. And if you're a new bankruptcy attorney, just contact a practicing bankruptcy attorney and find out if they're blowing smoke. In bankruptcy, a lawsuit is called an adversary. And an adversary, if it's filed, representation in a matter like that would be pretty much outside the scope of the debtor's attorney's agreement with the debtor. And they could either hire other counsel to represent them, or you would have a new representation agreement to represent them in adversaries. I don't hesitate in my practice. If it's an area like employment law, I'll have my client hire another attorney to represent them in the adversary. If it's something that I know, then like housing law, I will generally represent the client. And again, I don't believe I've ever had an adversary, and I've been doing this, I think, 35 years now, in a Chapter 7. So, but I need to tell you about it. Here's a really important part of bankruptcy representation. In 2005, the Congress, in its infinite wisdom, decided that people were filing Chapter 7s and they actually could pay, and they shouldn't be allowed to file a Chapter 7. They should be filing a Chapter 13 where they pay back their creditors some or all of their debts, depending on what their income is, what their assets are, etc. So there are two things you need to know about debt relief agency. One thing you should do is look it up in the code at 101, which is where all the definitions are. If you are a pro bono attorney, you don't have to worry about this. So if you work for ALRP as one of their pro bono attorneys, don't worry about it. If you are going to do a case for money, then you are going to be, that person who pays you is going to be called an assisted person. So when you look at the code, a person who provides bankruptcy to an assisted person who pays, then you are a debt relief agency. And there are rules about being a debt relief agency. I'm not sure if my slide doesn't go into that, but your material too. So take a look at the debt, if you're going to do a bankruptcy for money, take a look at what you have to disclose. One of the things you have to disclose, I'll just tell you right now, is you have to disclose that you are a debt relief agency, and you have to put it on your retainer agreement, and you have to put it in any advertising. So if you look at advertising by bankruptcy attorneys, if you go on the web and just look up bankruptcy attorneys, you'll see somewhere in their advertising, unless they're breaking the law, we are a debt relief agency, and they may go forward and say, we represent and advise assisted persons in bankruptcy. So, and then also one of the other rules about that's important about debt relief agencies is you have to give certain disclosures to your clients even if they don't hire you, you're supposed to give it to them 3 days after you say to them, or they say to you, I want to hire you, or you say to them, are you going to hire me? Then you have to give them these disclosures, and you'll find those disclosures under 342B B1 and 527B, or 362B small b, small I, and 527 small b. That's in your materials. Okay, now let's get to the initial, part 2, the initial intake. Your duties as a bankruptcy attorney. The first thing you're going to do, and in bankruptcy, this is really important. You're going to do an intake interview, and you have to understand your client's level of sophistication, which often is not very high, especially when you're dealing with economically disadvantaged people. Your client's level of stress. At ALRP, people often are under a lot of stress due to their health condition, due to their income condition, etc. So you have to take into account their level of stress. And then you have to remember your goals in the interview. That's important because remember, this is a kind of this is a kind of area of law where people have stories, and they often want to tell you their story. And you have to remember what your goals are, to get the information, still let them tell part of their story. And so you have to stay in control of the interview. Okay, evaluating the client during, was there something before this? Did I go too fast? No, I didn't. Okay, so evaluating the client during the intake. You meet with the client, you get the emotions, you figure out the emotions of the client, you establish rapport, and you figure out what their goals are, while remembering what your goals are. Red flags. Red flags are important in bankruptcy because a lot of times people don't understand that you, as the debtor's attorney, need the whole story. Tell me the truth, the whole truth, and nothing but the truth. That is absolutely necessary. And clients sometimes keep things that they're embarrassed about, or somebody's told them, oh, if you have that asset, you'll never be able to file bankruptcy. So they may not be truthful with you. And you have to impress upon them that you need to know everything. Are they giving you all the information that you're asking for, complete information? One of the things in evaluating red flags is, does this make sense? They, they made this much money last year, and they're only making this much money this year, or what does that mean? And so you need to delve into things that don't make sense to you. Are the goals that they have in filing a Chapter 7 bankruptcy realistic? Sometimes they will have unrealistic goals about what they want to get out of bankruptcy. Sometimes bankruptcy will not serve them and they need to do something else. And we'll talk about that in more detail as we go on. But take a look at their goals and make sure that what you can offer them as a bankruptcy attorney is something that is helpful to them. So when you do an intake, you need to get certain documentation from the attorney, the client. And I have given you just a few things that are helpful. Pay stubs are kind of necessary. Try to get 6 months worth of pay stubs. Account statements, bank account statements. If they have them available, get them. Don't scare people at the initial interview with asking for too much information. But, just say, I'd like to just look at your last 2 bankruptcy statements if you could get those to me. Last 6 months worth of pay stubs, full months, not counting the month you're in, if you can get those to me. Those are going to be important for you to find out if they're going to qualify for a Chapter 7 bankruptcy. So I think I was telling you about in 2005, the new rules that came down. And one of the new reasons for, or one of the things that came out of the new rules that we call back SEPA, is that you have to do a means test for the client. The means test is how they evaluate whether the client falls below the means or is at the means in order to file a Chapter 7. You're going to need those paycheck stubs. We're going to go into the means test in detail. If they have a co-debtor, such as a spouse, and that would be your only co-debtor, then you need to get their information even if they're not filing. If they own any real estate, get that information. If they own a car, get that information. Those are the two assets that generally make a difference. If they filed a lawsuit or a levy or a lien, or they have a levy or a lien or garnishments, repossession information, you should get that just so you see where they are. Divorce decrees and MSAs, marital settlement agreements, are really important if your client has recently had a divorce. I have an intake form. Some people don't think you need an intake form. If any of you would like to see my initial intake form, shoot me an email at sally@elkingtonlaw.com and I'll PDF it and shoot it to you. And this is a useful tool. It will help guide you through their financial situation. Mine has a lot of room for taking notes, and it'll give you a chance to make sure you don't miss anything. Let's see. Sorry. So in getting basic information, you will make sure you get their assets and their liabilities. Sorry. You're going to get their assets and liabilities, why they file bankruptcy, issue spotting, and notices required. So that's sort of an overview. Is the client eligible first to file bankruptcy? And I think this slide might be out of order. Let me see. And if not, we'll cover it later. Nope. So we'll cover this later. Okay, so we're going to go down to are they eligible to get a discharge? So this is you'll have it in your materials. There's an 8-year rule that's filing Chapter 7 to Chapter 7. There's a 6-year rule that's filing Chapter 13 to Chapter 7. 4-year rule that's filing a Chapter 7 to Chapter 13, and a 2-year rule filing Chapter 13 to Chapter 13. These are filing dates to filing dates. So you go from the filing date they filed their last Chapter 7 and to the filing date of the new Chapter 7. And 8 years has to have gone by before you can file a new Chapter 7 case. That's the one you'll need to know more than any other rule. The 6-year rule is when you're filing a Chapter 13, when they filed a Chapter 13 and they want to file a Chapter 7, has to be 6 years before they filed the Chapter 13, unless they paid all of their unsecured claims in the 13, or that they paid at least 70% of the allowed unsecured claims, and the debtor's plan was proposed in good faith, and the payments represented the debtor's best efforts. So 7 to 13 is in your materials. You don't really need to know about it. 13 to 13 is in your materials, and you don't really know about it. Okay, so where will the client have to file their bankruptcy? What's the proper venue? A bankruptcy petition has to be filed in the proper division and within the proper location in that division. So it might be the Northern District, but it might be San Jose Division as opposed to San Francisco division. It depends on their residence. And residence or domicile or principal place of business are all the three areas that you look at when you file a bankruptcy. A client can have more than one residence, but not just a stopping place for business, but they actually have to have a place where they reside at least a major portion of the time, or they have a principal place of business. So they do their principal place of business is in Oakland, but they reside in San Francisco. You can pretty much choose which division you're going to file in. So that's domicile is defined as the individual's residence with intent to remain there or return after they've been absent. An individual, as I said, could have more than one area of a residence, and we talked about principal place of business. 180-day requirement. The petition should be filed in whichever district the client has resided longer. So if within a 180-day period, they've resided in San Jose for 90 days and Oakland in 91 days, you're going to file in the Oakland division. The Oakland district, Northern Division, Oakland district. Okay. So the other thing you want to look at is, are there alternatives to filing bankruptcy? And that's really important because when somebody comes to you, maybe bankruptcy is not the best thing for them, or maybe the kind of debts they have are not debts that are dischargeable in bankruptcy. Or maybe they're judgment proof. A lot of people who are economically disadvantaged are judgment proof. So it's important to determine whether or not the person's income is exempt from being taken, levied, or have liens against their, or garnishments against their income. And that would be people who are on Social Security. Mainly, that's what you look at. And so their assets can't be reached by a creditor. Statute of limitations, debts mostly within 4 years, if you have a credit card debt and you haven't done anything, paid or charged anything for the last 4 years, then the statute of limitations would apply and they can't collect on those debts. The exception is, of course, if they filed a lawsuit and they got a judgment and then they go in and renew that judgment. And they can renew it every 10 years, and the judgment is good for 10 years. So you have to look at that. Very important to look at judgments and see if they've been recorded. Okay, some debts are not dischargeable in bankruptcy, such as student loans, recent taxes, spousal support, things like that. We'll go over that in more detail. And then sometimes I find, especially with elderly clients or people who are ill, that they just can't stand the creditor harassment. They would rather, even though they're judgment proof, they would rather file bankruptcy and keep the creditors from calling them, because creditors can call them even after the statute of limitations. And creditors' debts get sold and sold and sold and sold. And so a new collection agency starts calling. So you have to look and see if there are any federal and state protection available to them to stop the harassment. And I've given you that you should look at federal law. That's the Federal Fair Debt Collection Practices Act 15, USC 1692 et sec. All right. Maybe the debtor has just one creditor or only two creditors that are bothering them. I'm sorry, that's my dog. So you want to look at creditor feasibility. Is there a feasibility to paying off this debt outside of bankruptcy? So you want to look at that. Remember, there are payment plans out there by for-profit services that really only serves them. So contact nonprofit agencies and take a look at what their negotiation settlement requirements are. Advise clients to have everything in writing. Advise clients to have a payment plan that they can do. That's important. Sometimes clients will think, I can do that, I can handle that, when in fact, they can't. So, Chapter 7 versus Chapter 13. Chapter 7 is what we're talking about today, and a Chapter 13 is also referred to as a liquidation bankruptcy. We talked about a straight bankruptcy. Discharges most of the client's debts, the debtor's debts, protects their property, gives them a fresh start, and best for low-income clients. Chapter 13, maybe you're going to file a Chapter 13 bankruptcy for a low-income client, but probably not. So it could be that if they can't file a 7, they could file a 13, and that would be something you would want to either send to a more attorney who files Chapter 13, or you may want to call it someone like myself and say, I want to file a Chapter 13, and so can you help me through it? If the client is not a homeowner, has low wages, not very many assets, they're going to file a Chapter 7. And we'll know what their situation is by filing the means test. So can people who own houses file Chapter 7 bankruptcy? Yes. For example, Jenny Jacobs owned a home with only a first mortgage and her property has no equity. The home is worth $200,000. The loan is $220,000. In this situation, you're going to be able to protect that $20,000 worth of equity. And so she could qualify for a Chapter 7 and keep her home if she's current on the payments. The best way to figure out filing Chapter 7 and understanding Chapter 7 is working with a pro bono agency like ALRP. Retaining the client in a Chapter 7 case and due diligence. You need to get, if you're going to retain a client in a Chapter 7, you're going to get, I've given you a list of the materials of the documentation that they need to get you, but the documentation you need to get them are credit reports, county records, and PACER, do a PACER search. PACER is where all bankruptcies are listed for the last billion years. So you should be able to go in on PACER, and if you need more information about PACER, I can give it to you. But basically, just look it up, and it should give you some good information. Just Google it. All right. Due diligence. Let me look at the next slide. I think I may have skipped a slide. Oops. Sorry, folks. Due diligence. Wow, I skipped a few slides. All right. Retainer fees. You have to have a retainer fee. You need to state what your fee is if you're charging a fee. Scope of the services, even if it's a pro bono bankruptcy, you need to outline the scope of services. Any additional fees that you're going to charge, like if they want you to get their credit report, they're going to pay for that. If you have to pay for a PACER search, they should pay for that. Same thing with the recording, county recorder search, etc. Okay. Slide 25, retaining the client. In a Chapter 7 case, if a client decides to retain you you have a duty of due diligence. Once they've retained you, now you have to get a complete and accurate picture of their assets and their liabilities. Due diligence is actually set out in the bankruptcy code at 707 small b 4 large d. When you sign a bankruptcy, you're saying that I am certifying that I have looked at all of this. I believe that everything that I've put in the bankruptcy is correct. You're not saying everything I put in the bankruptcy the client told me was correct is correct. Everything I put in the bankruptcy, I clearly believe is correct. And that is going to be very important so that you don't get yourself in trouble. Sometimes a client will actually keep something from you that is very important. It has happened to me in bankruptcy, and that for some reason they have decided to come back after the fact and say, oh, by the way, I own a piece of property in Maui. And so we're going to have to redo their bankruptcy to some extent, maybe convert them to a chapter 13. All right, here are some things that you should always collect. They're in your materials. Documentation I covered that you need to get, also in your materials. And then we need to look at timing. Sometimes, if they have taxes in their bankruptcy, even though they're not dischargeable, timing of the filing may be very important. If you file the bankruptcy before some of those taxes are dischargeable, that could be a real problem and for you and the client. So if you have taxes, you may want to talk to an attorney to find out if, and they'll show you how to take a look at the timing of filing the bankruptcy. Also, reducing non-exempt assets into exempt assets. We're going to cover that later. The transfer of property, we're going to cover that later. Paying insiders, we're going to talk about that. All of these things we're going to talk about a little bit later. Okay, so I think we are on our next set of slides, the means test. I mean, look at our timing here, almost halfway through. This is a difficult part of bankruptcy. I would say means test and exemptions are the most difficult part of filing the bankruptcy. So let's cover the means test. The means test requires, and I gave you a copy of a means test in your materials, so you may want to look at it. Cases filed by individuals that have primarily consumer debts may be involuntarily dismissed if the case is an abuse of the provisions of the means test. Now, the means test does not apply to everyone. If a qualified disabled veteran, the means test is not applicable to. Debtors whose debts are not primarily consumer debts, like business debts, even if it's not a business bankruptcy, but they were responsible for these business debts, they don't have to do the means test. And Section 707B2 sets out the means test. And you're gonna look at the current monthly, calculate the debtor's current monthly income and determine in the means test if the client is above median. And this is in section bankruptcy code form. The form is 122A1. So in your materials, I gave you a copy of 122A1, and it's a series of subtraction. Here's addition and subtraction. Here's their last 6 months of income, and here's what we get to subtract. And you get to subtract a lot of things. You get to subtract taxes out of their income. You get to subtract healthcare. You get to subtract car payments, things like that. So the form is going to give you a sense of that. Form 122A-1 is basically the addition of the last 6 months worth of income, gross, and whether they pass a means test or not. 75% of your clients are going to only have to fill out that form because it doesn't exceed the defined level of the means test of what the amount of debt they can grossly acquire that in terms of the year they're filing. Now, let me tell you, the means test makes little or no sense in some ways. When you add up the last 6 months of gross income, you then multiply it by 12, and that gives you, you get the average income, I'm sorry. So you take that average income, you multiply it by 12, and that gives you the defined amount of income that is going to be subjected to the means test. So, you know, maybe a client made very little money in the last 6 months, but in the next 6 months, they're going to make a whole lot of money. You know, in many ways, that doesn't matter. So, I mean, technically, the debtor might, you might find a trustee who says, you've made very little money, do you expect to make more? Well, if the debtor doesn't know, the debtor doesn't know. If they think they might, they think they might. But most of the time, people can't, I have not been guaranteed that. Okay, so Section 707, small b2 sets out the means test. After you calculate part 1, calculating the debtor's monthly income. What kind of debts? We've already done that. They have consumer debts. Are they in military service, active military service, or are they military disabled? This would be, are their debts primarily for personal, family, or household purpose? Student loans can be consumer debts. Oops, I'm sorry. I did that too soon. Mortgage debts are probably consumer debts. Tax debts are not consumer debts. Tax-related car accidents are not consumer debts. They're actually, you can't discharge them. Well, you can, but there's one caveat to that we'll cover. And primarily, more than 50% of the debt is consumer, then it's consumer debt. All right, part 1 of Form 122A-2. You determine the adjusted income. You calculate the deductions from your income that we talked about. And it's all in the means test paperwork. I'm sorry, I've got to catch up with myself here. So you take the average monthly income from all the sources that the debtor or the joint, if it's a joint case, or if the debtor is filing singly, but they have a spouse, you have to count the spouse's income as well. During the 6-month period, just preceding the day of filing and ending on the last day of the month. So if we filed immediately preceding the filing. So if we filed this month, which is September, then we look at August and back 6 months. February, March, April, May, June, July. So it's March through August. Then we did consider their household size. There's 2 ways to look at household size. Heads on the beds, how many people live in the unit, or economic unit. So, okay. So household size, heads on the beds approach. That's what I use. Who's living in the property is really, really important. And, or in the unit that your people live in, reside in. If it's a roommate, and the roommate makes no contribution to the income, then it would not be heads on the beds. If you have signed a lease and you each signed and you each pay the landlord separately and there's no mixing of income, etc., then you don't count that person as a head on the bed. But if they pay you and you pay the landlord, they may be a head on the bed. The other is economic unit. Mother, children, mother and father, children, father, children, father and father, children, whatever the economic unit is, you would choose that. Now, let's say you've got a kid that's 26 years old, but still living at home, even though you don't claim that child as a dependent, still would be part of the economic unit. Okay, you have to include contributions for household expenses from members of the household as income, which I basically said. Deduction. That was the right slide. Yes, deduction issues. So you can deduct, as I said before, compulsory retirement contributions. You can deduct household expenses. You can deduct tax withholdings, or like your taxes. Child care is deductible to a certain extent. Vehicle operating expenses, and there are just things that you will go through. Now, some of these will be actual numbers, and some of these will be based on the IRS's determination of what the expense should be for a household of 4 or a household of 5. That's why it's important to know how many are in your household. The more in the household, the higher the deductions will be. Excuse me 1 second.
Sally, you're muted.
Yeah, I'm sorry. I had to turn on a light in here, and I didn't want you to hear me talking to Alexa. Okay, so you're going to determine whether there's a presumption of abuse. If you fail the test and it creates a presumption of abuse, if it's under the applicable median income or within what they call the safe harbor, so you might have some extra money there, but it's within safe harbor, means test will tell you there's no assumption of abuse. If it's over the applicable means median income, then you may have a presumption of abuse. Chapter 7 trustee could make a referral to the United States trustee, and the United States trustee would bring a motion to dismiss. There may be special circumstances that would put you under the presumption of abuse, like in a married couple, if your spouse, if you have separate income and your spouse and you have separate expenses that you keep separately, your spouse has their own credit card, their own car payment, etc., they're on those credit cards and that car loan, you can subtract their expenses in the means test to lower the actual means test number. And so you're going to give you're going to give details about those special circumstances. You have an opportunity to rebut the presumption, and there are situations where the presumption of abuse may not be rebuttable. What do you do? Go back and redo your numbers. Have you missed anything? Have another attorney take a look at your numbers. I am basically of the opinion most people who do not own houses or really expensive cars can pass the means test. So have somebody else take a look at it. Filing a Chapter 13, is that an option? Should you explore the other alternatives that we talked about? Is there anything else you can think of that would help the client pass the means test? Now, I'm going to take a second here to talk about the best way to fill out means test information. First of all, if you are going to file bankruptcies, my advice is to get a bankruptcy program. Some of them can be pretty expensive, but many of them are affordable. So I don't know if ALRP provides a program. Some pro bono services do provide a program, and the owner of that program or the distributor of that program has given the nonprofit, especially nonprofits like ALRP, a chance to give their bankruptcy program out to people who are part of their panel. I don't know if they have. If they haven't, actually, I'll talk to ALRP about that. But in the other, if not that, look for bankruptcy programs. I use, and this is not an advertisement or something that I would say is, that I'm saying is the best, but I use Best Case Bankruptcy. And if you're only going to file Chapter 7s, it's cheaper, but there are lots of other, there's Jubilee, I can't even think of all of them, but there are a lot of other alternatives out there. That they will ask you information, and then they will fill in where that information falls in other documents. And that's really helpful in the means test. It kind of does it for you, does all the subtraction, addition. It makes a whole big difference. So that would be my suggestion. All right. You may have questions about this. Think about it. And if you go over the materials that I've given you, and if you can't think about what your questions are now, we'll talk about them tomorrow. Section 4, filing a Chapter 7 bankruptcy case. Basically, there are 3 requirements to file a bankruptcy. Filling out the official form, bankruptcy form. The client has to take a pre-bankruptcy credit counseling course. That course has to be approved by the United States Trustee's Office, and it has to be taken within 180 days prior to the bankruptcy filing. And we'll talk about credit counseling in more detail next. Paying the filing fee. The client has to pay $338 as a filing fee, or if they qualify for a fee waiver, and often if you're not taking any money and they pass the means test on the first part of the test, which means they don't have additional monies, they probably will qualify for a fee waiver. All right, and the fee waiver again will be it's one of the official bankruptcy forms, and if you get a program, you can fill it out right through the program. Who has to take credit counseling? The UST determines, oops, I don't know how we got there. The UST determines that you don't have to take it if courses are not available in your district. But since all of them are offered by video or through the internet or by telephone or some cases in person, that's not a very likely scenario. If there are exigent circumstances, the client must have contacted an agency that provides the credit counseling course, but they were unable to complete the course within 7 days of contacting the agency. They had to file bankruptcy immediately. Let me just tell you, there are few and far between exigent circumstances, especially in Chapter 7. So what you need to do is have your client take the counseling session. They can take it the same day they file the bankruptcy, as long as they've finished it and have their certificate, so you can file the certificate with the bankruptcy. Some exigent circumstances is to prevent some type of significant harm, such as a wage garnishment, sale of property. So here's a scenario that I have thought of. Your client has finished all the bankruptcy forms with you, and you're ready to file. All they have to do is take the credit counseling course, and you're going to file it the next day. They're going to take the credit counseling course that day. They're in an accident that puts them in the hospital. You need to file the bankruptcy because they're going to have a wage garnishment the next day. And we can undo wage garnishments, so that depending on your judge, that may or may not be an exigent circumstance. But the fact that they were going to take it, were in an accident, went to the hospital, couldn't take it, there was a sale of their home the next day, or there was a court hearing the next day that would create a judgment in their case, those might be exigent circumstances. That doesn't mean they never have to take it. That's just a Band-Aid, and they will have to take it within 30 days. If they're incapacitated, like from a mental illness or an impairment to the extent that they have a disability that doesn't allow them to, that physically prevents them from completing the course over the phone or online, they may not have to take the means test. The disability situation is not, I've never seen it. I'm sure it happens some places. The incapacitated, I have. If you have an older client or a client that has dementia and they really can't make rational decisions about their financial decisions, they may not have to take the means test. If they're on active duty in a combat zone, they do not have to take the means test. We've used that, but we probably are going to be not using it much anymore, that we are now not a part of our Afghanistan situation. Okay, so petitions and schedules. All right. So what's in a bankruptcy? On this slide, everything that's listed is in a bankruptcy. Sometimes a client will come in and you will need to file a bankruptcy very quickly, and you don't have time. And I don't recommend this because A, it's difficult to complete, and B, and you're limited in the time to complete, it's risky. You could file a skeleton filing where you file the petition and a list of all the creditors in the client's case. That's called a matrix. You also have to file their statement of social security number. You have to pay the filing fee or the application for waiver, and they have to have their credit counseling certificate. I just wanted to tell you that, but I don't think you should file it because you have 14 days to complete it. It's hard to file the completion, and oftentimes if you haven't gotten that information from your client, it's going to be difficult to get it because they now are breathing a sigh of relief because whatever disaster that was about to happen is over. So file the whole thing. So the full filing is all of these forms down here, what the schedules are, etc. And you have to file each one of these forms. And I'm looking to see if there's anything that you don't have to file. Nope. File all of those forms. So fee waiver. Can my client get a fee waiver of bankruptcy filing fee? If they fall behind 150% of the poverty line, and that's a Form B 103, I put here 103A, but I think it's 103B. Look at both. And if they fall, they must be 150% of the poverty line, not below, I'm sorry. And they're unable to pay in installments, then, and it can't be a business, then, and are only available in Chapter 7, then they might be able to get a waiver, especially if you're not taking a fee. So go ahead and fill out the paperwork and see if they qualify. And the application fee, filing fees, installments, they have 120 days after you file the bankruptcy, and the court must approve the payment timetable, and that's the procedure, I believe 103B. No, I'm sorry, it's Form B 103A, application to file the filing fee and payments. And if they don't file, and again, I don't like this because it's up to the client to do it, not you. And if they don't do it within 120 days or something bounces or their credit card doesn't go through, then the case will be dismissed. And you've got to start all over if you can. Okay, filing requirements. Many, if not all, courts require you to use the ECF, which is electronic filing system. Your district will have to train you in that filing. All you have to do is call the ECF office or Google them and go online to ECF or electronic filing system, and they will provide you with the course, which is kind of an online quickie course. With COVID emergency orders, there are emergency orders for filing procedures. So it may be that you would be allowed to file in person. Again, you'd have to look at your district and see what they are providing. Better that you just become ECF efficient. Almost everything in federal law right now, you have to file electronically. It's actually wonderful because you can file up to midnight and you have hit the day of filing. So if you have a deadline, you've got till midnight to get the filing done. Of course, in an emergency situation, you can do a paper filing with the proper court. Go on the website for the court, for the district. I'm sorry, for the division, and find out what district and then where the court is. Okay. Amending schedules. When do you amend and what do you amend? You should amend schedules as soon as you discover that a mistake is incorrect. So I had a meeting of creditors. It seems like it was yesterday, but I think it was today. And the trustee pointed out something that she believes I need to amend. I disagree with her, but it makes no difference. So I'm going to go in and amend the schedule today before midnight, and that will make the trustee happy. So you can amend anything. You can amend any part of the bankruptcy that is incorrect. So if the client says, oh, I forgot a creditor, you can amend. What you do if you're going to amend is you amend that schedule, which if it's another unsecured creditor would be Schedule F. And then you file it with the court, you make a copy of it, and you send it to the trustee so the trustee knows that you've amended it. Doesn't really matter. They're going to get notice. And you can file anything that's incorrect. A debtor must sign the declaration for an amended part of the bankruptcy. So there are declarations in each part of the bankruptcy, and the debtor has to sign them. They cannot e-sign their bankruptcy, any part of their bankruptcy. I had a client this morning said, when asked, did you sign all your documents? He said, yes, I e-signed them. And I was like, oh God, no, you didn't. And then he caught himself and said, no, I did sign them and scanned them and sent them to my attorney. So that's important. Things are all done on Zoom nowadays. And one of the things you do want to do, and I'll cover this again, but you do want to have a Zoom meeting with your client or an in-person meeting, because there are certain documents you are going to want to see and you have to see in person. And that could be their driver's license and their social security card or proof of social security. So plan a Zoom meeting with your client if you don't want to see them in person. I have some immune deficiency problems, so I don't see clients in person generally. I see them through Zoom, and it works out perfectly, and they love it because they can be in their jammies and I can be in my jammies. Okay, so the next area, and I'm going to get through as much as I possibly can in the next half hour and 4 minutes. These are the exemptions. So in considering filing a Chapter 7, you have to understand the exemptions, because what happens in a bankruptcy is you file the bankruptcy and all of a sudden, all of the debtor's property becomes a part of the bankruptcy estate. Everything the debtor earns and owns becomes part of the bankruptcy estate. And so think of it as going into a big basket. Now you're going to cut holes in that basket, and some things are going to come out of the bankruptcy estate because you're going to file an exemption to protect them. So all property in the beginning becomes part of the bankruptcy estate, except those things that are exempted. And the trustee owns that bankruptcy estate. The property, as I said, the property they own, or their real estate, their car, their furniture, they possess it, but it's part of the bankruptcy estate. It also could be security deposit. It could be commissions. It could be royalties. And then you have to think, when was that commission earned? Even though they haven't gotten it yet, it still may be part of the bankruptcy estate. Accounts receivable. So they've earned that money. It hasn't been paid to them, but it's owed to them, so it's a part of the bankruptcy estate. So any loans owed to them could be part of the bankruptcy. Any property acquired within 100 days after the case is filed, 6 months after the case is filed. So you file a case, you exempt everything you're supposed to exempt. The client calls you 3 months after filing and says, oh my dear God, unfortunately, Uncle Harry died and he left me $5,000 in inheritance. We have to then go back, open your case up. Well, first of all, maybe you could protect that $5,000 in your bankruptcy. So you're going to go back and look at the case and see if you could protect Uncle Harry's inheritance if you reopen the case and put it in as an asset and then protected it. So in that case, you might want to just call the trustee and say, look, Debbie debtor got an inheritance for $5,000 just now, but if I open the case and I put it in as an asset, I have enough exemption to protect it. Are you going to want to go after it? Do you want me to do that process? And some trustees will say, absolutely, that's a letter of law. Some trustees will say, no, don't bother. It's not enough for me. Just send me the paperwork so I can see that it could be, and I know that it can be exempted or protected in your bankruptcy. So you'll work with the debtor, the trustee. You're going to get to know, if you do enough of these, you're going to get to know the trustee. And it's, again, another time you want to have a good relationship with the trustee, because you can see that trustee over and over again. All right, so that covers inheritance. It could be a property settlement agreement with a spouse in a divorce decree. It could be you could be a life insurance beneficiary. Anytime something comes into your estate, the attorney needs to be told. You need to make sure your client tells you so that you can file a supplemental schedule if necessary, even if the case is closed. Failure to report might revoke the discharge of all the client's debts. So they need to understand that. Failure of them to tell you that they can revoke, that they inherited something or got life insurance or something happened that put more money in their estate other than income, earned income, then if they don't tell you and the trustee finds out, which they can, and we can talk about that if we have time, who's likely to tell them, it could revoke their discharge of all of their debts. An estate includes community property, whether or not the debtor is filing a joint petition. So you need to include community property in your petition, whether or not it's a joint petition. So if you're just filing a single petition, put all the property in it in your house. Trustee is going to say if she knows that you're recently divorced, or if you are married and you obviously have community property, it's going to ask you, does your wife or husband own any property that is not listed in your schedule? Now, if the wife owns a house, that makes things a little bit more difficult, or a husband owns a house, because that's maybe community property and you're going to have to prove it's separate property. So that's where you need to know a little bit about family law. And again, this is when you've got to call somebody who knows these things and check it out with them. I will tell you that most bankruptcy attorneys are happy to help people who are just starting. I am one of those people. I have no problem looking over your stuff and helping you figure things out. So, and I can give you names of others. Okay, marital property. Preferences. We're going to cover preferences in more detail, but just know that if a client pays a debt or transfers property worth more than $600 to a creditor within 90 days before filing their bankruptcy, or if they're an insider, and we'll talk about what an insider is, or 1 year if the creditor was an insider, that trustee can bring that asset or money back into the bankruptcy estate, and they then can distribute it to creditors. So, as an example, if you want to pay off your car and you owe $1,000 on it, and you pay that $1,000 up front, the trustee could go to the car creditor and make them give back the $1,000, and you would have to own minus what your regular payment is in order to pay other creditors. In all reality, the idea here is no one creditor should get any more pro rata share of your estate than any other creditor. All creditors of the same type, like an unsecured creditor, or all creditors of the same type, like a secured creditor, have to be treated the same. There can't be unequal. I like this creditor better than I like this creditor. I want to pay Bank of America because I have a checking account there, but I don't want to pay my Capital One card because I don't care about them. Cannot do that. Cannot do that. Everybody has to be paid the same amount. And if you make a preference payment, and we'll talk about insiders in more detail because that's always problematic, the trustee will go get that money from that creditor and pay your and spread it amongst your creditors. Anything less than $5,000, more than likely the trustee won't bother with. It depends on the trustee and how hungry they are, quite frankly. So you can't count on it, but you're going to need to, these are things you're going to, in your issue spotting, these are things you're going to have to look at and find out about. Have you paid any creditor, unsecured, secured, in over $600 in the last 90 days? No, I haven't. Have you paid any family member or good friend or business associate any money over $600 in the last year? That's the problematic one. So we'll cover that in more detail later. Okay. There are also transfers with the intent to defraud creditors. And this is just basic law. You cannot make a transfer with intent to defraud creditors. So if I stop making some payments on a credit card and they sued me and they got a judgment and I know they're going to go in and execute on that judgment and I own a house, I can't call my sister and say, I'm going to do a quick claim deed and transfer the property to you so they can't put a lien on it. So there's no lien on my property. You can't do that. Even if you're not in bankruptcy, you can't do that. You cannot hinder a legitimate creditor who has the right to a lien or a garnishment or something like that. More to the point, not garnishment, but a lien or a repossession. You can't try to foil them by transferring the asset out of their name for no consideration or for little consideration. In other words, oh, well, I better get some money from you so my $600,000 house, I'll transfer to you for $6,000. Can't do that. That's considered no consideration, even though it's little consideration. And we'll go over more about transfers with the intent to defraud. Property that is not part of the bankruptcy estate and not exempt is transferred to the trustee for the benefit of the creditors. There's some property that basically is not part of the bankruptcy estate, like retirement is not part of the bankruptcy estate. Always listed, and there is an exemption for it, so you'll want to exempt it. All right, exemptions in general. The debtor is able to keep property that is exempt. Review with the client or the debtor the property that is exempt in determining whether to file bankruptcy and what type of bankruptcy. If they have a house, how much equity? If they have a car, how much equity? If they collect antique furniture, what is the amount of their antique furniture and can you exempt it? Congress enacted a set of federal exemptions. California has opted out of those exemptions, and we have our own exemptions. And we're going to talk about those. So an exemption in just general helps to protect certain items without regard to value, such as tax-exempt retirement accounts, Roth IRAs, traditional IRAs, and their limit is about $1.4 million almost, and it's regardless of whether it's state or federal exemptions. Okay, when you do your intake with the client and they've hired you and you're now collecting documents, etc., you're going to ask them to value their property. And I always ask my clients, value your property as if, and I'm talking about personal property, housewares, furniture, clothing, sports equipment. You're going to put it all out on your lawn or your front porch on a Saturday and you're going to have a garage sale, what are you going to get for these, for your furniture and furnishings, for your clothing, for your sports equipment, et cetera, et cetera? How much are you going to get for it? That's valuation. And then you're going to look at those numbers because clients either way overvalue their property or way undervalue their property. And so it's important to look at it and sort of figure out. I always tell them, one thing you can do is go to the Goodwill or one of the places that you donate stuff to, and they usually have a list of what you can put on your receipt based on what you're donating to them. So that's a way of valuing. It's fair market value at the date of filing. 522A2 determines what property can be sold for at the time of filing, and you ignore liens on personal property when computing the value. Appreciation in property accrues to the trustee. So if your client has baseball cards and values them at X amount, and they have one baseball card in particular that has just gone up sky high in market value for some reason, after you file bankruptcy, if there is a increase in the amount of the value of the property, that belongs to the trustee, and the trustee could sell that card if you can't protect it and pay off your creditors. So there's a case I've cited here that you may want to look at. Vehicles, you're going to use Kelley Blue Book or the NADA Guide or Edmunds. Use Kelley Blue Book, that's what the trustee used. If you have an old vehicle and Kelley Blue Book doesn't cover it, use the NADA Guide or Edmunds. Homestead exemption. I'm sorry, we're going to talk about converting property. Pre-petition exemptions. Pre-petition exemptions, that's where you can convert assets of the estate of non-exempt type into property that is exempt. So I have a client, quite frankly, who has $10,000 in a bank account. He has other exemptions I've had to take it's called a wild card exemption, and we've used it up, and I can't protect all of that $10,000. He doesn't have a car. He rents a car. This actually is an AARP client. He rents a car every week, and it's costing him $1 million. So I said, take your $10,000 and go buy a beater. Then we can protect that car and not worry about your $10,000. Or if you spend $8,000, whatever. I don't know what used cars go for nowadays, but whatever it is, go buy a car. And also, before you're filing, if they're going to get a car that they have a loan on, they're going to be able to pay a lower interest rate than after you file bankruptcy. So that's converting the asset from an exempt, non-exempt type into a property that is exempt. There is some risk that it may be, it could be looked at as an attempt to defraud creditors, but most of the time it's not. Also, there's a right to redemption. You can pay the property's value in cash, or you can substitute an exempt property of equal value. So let's say I can't exempt, I gave you an example before, but it wasn't a great example, but let me see if I can give you an example. Let's say that we can't exempt all of a car, and the trustee decides they're going to sell that car, you can say, well, I have a car. I have $5,000 in equity in that car that I can't exempt. But I have this other car that's worth $5,000. So I'm going to keep the car that has equity in it, and I'm going to give you this other car that's worth the same amount, and you can sell it. So you can that's redeeming. You can substitute the exempt property of equal value. The trustee or any creditor can object to your exemptions within 30 days after the meeting of creditors, or within 30 days after the debtor files an amendment. One reason to file an amendment to exemptions quickly. It then can, unfortunately, it will prolong when they can object to it. So I have, in a chapter 7, I have not had any, in 30-odd years, I have not had anybody object to an exemption in a chapter 7. I have in chapter 13, but not chapter 7. Okay, exemptions generally secured creditors. Secured creditors retain their rights against their collateral. So if you're paying off a car, the creditor has a right against that car based on what their loan is. And they're entitled to take back the collateral if you are not current and if you do not file a statement of intention. That's one of the forms you have to file. Even if there's no secured debt, you're just going to file it blank. The debtor files a statement of intention within 30 days after the meeting of creditors, and it states, I'm going to surrender this vehicle. Let's talk about a car, it's the easiest one. I'm going to surrender this vehicle. I'm going to redeem this vehicle. In other words, I only owe $1,000 on it, so I'm going to file this motion to redeem, and I will take $1,000 and pay it off at value. I shouldn't have said I only owe $1,000 on it. I should have said it only is worth $500 more than. Let me see how to say this. In a redemption, what you want to do is pay off the vehicle at its value. So if you owe another $4,000 on it, but actually the value of the vehicle is only worth $500 more than the loan, then you can pay it off with that $500. You have to file a motion, ask it approved. They're going to object to it. They're probably going to work out some kind of settlement with them being the creditor, and it'll be done. A surrender, I already talked about that, and a reaffirmation. So surrender, you have to redeem or reaffirm the debt within 45 days after the meeting of creditors. I said 30 days. No, 30 days you have to file the statement of intention, and within 45 days, usually the creditor will sell. This happens all the time in Chapter 7. Usually the creditor, I would say, in my case, 99.9% of the time, the creditor will send you a reaffirmation agreement, and you will look at that, fill out the things they haven't filled out, check what they've filled out, and then have your client sign it. If you don't make the deadline and your client decides not to file a motion to or file a reaffirmation agreement, I don't like reaffirmation agreements, because what it does is it reaffirms the debt, which means that if the client should default on that debt in the future, the creditor can come after them for the money they owe the creditor. And there's no automatic stay to protect the collateral. If they don't sign a reaffirmation agreement, it means that if, for example, they default on their payments later after the bankruptcy is over, you've already discharged anything they owe, so it doesn't matter. They can't come after them for anything they owe. Clients like reaffirmation agreements because they get scared if they don't sign one, the debtor could repossess their car, and that is true. Very few creditors do that. They don't want the client's property, they want the client's money. I don't like reaffirmation agreements. I like surrenders, especially if they have a big old ass car that's got a big old ass loan on it. I say, give back that Ford Escalade and buy yourself a better car, a car that makes more sense with your income. Okay, on surrendered property, the creditor has to go in and file a motion for release and stay if the bankruptcy is still open in order to take the surrendered property. So if we surrender it in the bankruptcy, the creditor will do one of two things. They will either come in and file a release and stay to get the car right away, or they'll wait till the bankruptcy is over. We haven't filed a reaffirmation, and they could not have to file a motion for release and stay and just take the vehicle. But they generally don't. Don't do a reaffirmation on anything other than a vehicle. If it's a mattress, do a redemption, or say you want to surrender it. Who comes and gets a mattress? They can't resell it. They're not going to do anything. The debt's going to go away. Okay, California, this is where it gets interesting, I think. California has two sets of exemptions available. I'm going to see whether I'm going to go into that now or if this is where we will pick up on, just let me see how much more we have to do. Hold on, I'm sorry. I think what we're going to do is pick up on California exemptions when we come back tomorrow. That would be slide 60. I have to write that down. Slide 60. So now I'll entertain any questions in the last 7 minutes, or 7 minutes that anybody might have. I see in chat there is okay. If I want to wrap up, is there anybody? Does anybody have any questions or anything you want to ask me? No.
I don't see any questions.
No questions. You took it all in, and you're totally satisfied with what I said, and well, good for you. All right, then we'll pick it up tomorrow at slide 60. Can we stop now?
Yes.
Work? All right.
Yes.
We'll
So,
your late dinner, and we'll pick it up tomorrow.
yeah. So I just want to thank everyone for coming, and hopefully you'll return tomorrow. Just want to thank the HIV Legal Services Fund of the American Bar Association HIV/AIDS Impact Project, and the State Bar of California is certified ALRP as provider number 2485 to provide MCLE credit. I'm putting the evaluation in the chat, as I mentioned I would, but when this ends, you should also get a survey, and the follow-up email will also have that. I'm going to stop our recording.
Let me mention one more thing.